In this episode of the Boorman Lawyers Court Reports show, we discuss a very serious traffic matter, including multiple major traffic offences that we appeared on at the Southport Magistrates Court in Queensland.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at the distance. This is for the ones who ain't afraid. And this is more than some paper chase. I wonder who else can say the same.
G'day, Josh Boorman here from Boorman Lawyers. I just want to give a court report update today. I've just come from Southport Magistrates Court on a very serious offence for our client. He was charged with 4 separate offences on the one occasion, namely drive with high range blood alcohol reading of 0.165. He also had an unlicensed driving offence and a drive with having an alcohol interlock device fitted into his vehicle. He was also charged with high level speeding at the time. To make matters worse for my client, it was his 3rd drink driving offence. He had a high range drink driving offence about 2 years ago at Southport Magistrates Court, and about 7 years ago he was charged with a low level drink driving offence. On this particular occasion, he had gone to a Christmas party in Brisbane. He'd put a plan B in place to catch trains and buses to get to Brisbane to get back. However, he got back to Helensvale train station late at night. He had his friend's keys and bag in his possession. He was told that he could drive the vehicle, but throughout the night he said that he wouldn't be driving his friend's vehicle because he was to catch a bus to get home. However, when he got back to the train station, he missed his bus. He had the keys in his pocket and unfortunately succumbed to the temptation of getting into the vehicle and driving a car when he should have been nowhere near a vehicle, given his blood alcohol reading and the fact that he wasn't licensed. Police actually charged him with unlicensed driving and said that he was still under disqualification. We negotiated that particular offence to a lower level of unlicensed driving offence because he had actually his disqualified driving from 2 years ago had expired, so he wasn't actually driving on a disqualified licence the night he was caught. So it became a simple unlicensed driving simpliciter charge, what they call, and that dramatically reduced the seriousness of the offence. But in saying that, high range drink driving, no licence, no alcohol interlock device, and speeding at the time, it was a very serious matter that my client found himself in. We were able to do a lot of preparation for this case, and our client was able to show the court that he had taken some significant positive steps to address his offending behaviour since this incident occurred. In prior occasions, he had just gone to court, copped the result on the chin. He was unrepresented and he did no preparation before going to court. However, on this occasion, he owned up to the fact that he clearly had a problem with alcohol. He got along to see a psychologist and had a number of treatment sessions with his psychologist in relation to alcohol abuse and depression, which have been going on for a number of years now. And it just showed the court him voluntarily going along and obtaining psychological intervention to address his problems was a good positive step in the right direction for him to deal with the root cause of the offending behaviour and to show the court that he was serious this time about ensuring that he doesn't re-offend and appear back before the court again in the future. So he got several sessions of psychological treatment under his belt. He got a report from his psychologist providing the court with information as to his alcohol abuse disorder and also his depression, and also a future treatment plan going forward for him to stick to try and remove alcohol from his life. He also went along and did the QTOP program, the traffic offender program, which gave him a significant insight as to the dangers of drink driving, and it was a timely reminder about his responsibilities as a driver on the road. All in all, he could have been facing a period of imprisonment coming out of this situation due to the fact that only 2 years ago he had a high range offence, he had another high range offence, unlicensed drive, and the other offences before the court today. So it was a very serious situation that he found himself in, and it needed some very heavy consideration as to how we prepared the case and presented it before the court. We were able to get some good, strong character references from his employer, his wife. We also got the psychological report, the workbook from the QTOP program, and we helped our client put together a very wordy and strong letter of apology to the court. All in all, we got a very good outcome for our client. He was given a fine for the speeding offence. He also was given a period of 14 months disqualification for the high range drink driving offence as a second offence within a 5-year period. He also received a 3-month disqualification for the unlicensed drive. If it had have pursued forward on the disqualified driving offence, which was initially put in place by police, he would have been looking at a minimum of 2 years. However, we negotiated with police for a lesser offence, and that attracted a 3-month disqualification. He also received a 3-month disqualification in relation to driving a vehicle that should have had an alcohol interlock device in the vehicle. So all up, and prior to today, he had already been off the road for a period of 4 months since the offence occurred. On top of that, going forward today, he received 20 months in total for the high-range drink drive, unlicensed drive, and drive without an interlock device in the vehicle. So it was a good positive outcome. He knew that he was going to be spending a significant period of time off the road, but we were able to reduce the period of disqualification down significantly, especially negotiating with police to remove the disqualified driving and have a general unlicensed driving simpliciter charge put before the court. In addition to that, obviously the court wanted to put in place some sort of specific deterrence and penalty to put my client on notice going forward into the future that if he does break the law again, then he would have to be brought back before the court, and he certainly would be facing a period of imprisonment if he does break the law again. So subsequently, the magistrate sought to put him on a 12-month period of probation, which means that he's got to go along and report to probation and parole and be of good behaviour for the next 12 months. He's got to check in with them weekly and be under their supervision for the next 12 months. If they direct him to go into some sort of alcohol counselling or sober driver courses, then he will need to go and comply with those directions. But the mere fact that he has voluntarily engaged a private psychologist and he's already treating his alcohol issues, it's unlikely that they will send him along to do any additional alcohol counselling, because he's already got those wheels in motion and that process on foot. So ultimately, there was a very big risk that he could have been receiving some sort of imprisonment, whether that be full-time custody or a suspended jail sentence, but we were able to avoid that situation today. 12-month probation, 20 months disqualification from today, and a $500 fine. There were no additional fines in relation to the more serious offences before the court. He only received the $500 in relation to the speeding offence. The client was completely relieved about this outcome. He's obviously learned some significant lessons and realises that he needs to commit to his alcohol rehabilitation and treating his depression going forward so that he doesn't end up in a similar situation in the future. So at the end of the day, we got a very good result for our client, who was in a very serious situation with 4 quite serious offences arising out of the one senseless decision he made to get behind the wheel of a car, his friend's car, and drive on the night that he was charged. So guys, again, if you've been charged with any sort of drink drive, drug driving, unlicensed driving, disqualified driving, any sort of serious traffic offence, that's what we specialise in. We appear at courts throughout southeast Queensland and also in New South Wales around the Sydney area. Sydney and New South Wales have different laws, so it is worth keeping note that each matter from different jurisdictions need to be handled differently, but our client was very happy today. If you found yourself in a serious situation like this, please feel free to give me a call. Ask for Josh. You can call us on 1300 941 900, or alternatively go along to our website, which is boormanlawyers.com.au. That's Boorman, Boorman, lawyers.com.au. There's a heap of information there. We've tried to create a bit of a information hub for the public and anyone in a similar situation to read up blog posts, articles, issues on offences and penalties in Queensland and New South Wales, and there's videos there, statistics there, and case studies there that you can make yourself more familiar with in relation to your particular situation. And as I said, you can give me a call, 1300 941 900, to discuss your situation, and I can talk with you through your matter and how and the potential likelihood of penalties that you may receive, and obviously discuss with you how we can best represent you and prepare a case for you when your matter comes before court. Thanks for tuning in today, guys.
Mm-hmm.